Certain groups or individuals in our society, I suppose I would generally call them non-state, anarchist, libertarian organizations or individuals, hold that non-state justice, i.e. private systems of conflict resolution, are preferable to those presently operated by the state, i.e. courts, juries, prisons, police, etc., are not the ideal system for meting out justice, but private, mutually agreed upon arbitration is the best way to do it. Now, in theory, that looks good, but in my job, I have everyday hands-on experience with arbitrations. And the entire concept of arbitration is in many ways the antithesis of our present justice system. At least in theory, and in my opinion, my reading of the evidence before me, in practice, the justice system attempts at meting out justice. It understands that, it seems an a priori understanding that it will generally not live up to its own goals, but inasmuch as they are possible to live up to, it will make every effort to do so. And I can't see a system that can replace the present one, at least in terms of objective justice. The reason I say this is, in our present system, the assumption, at least in a proper modern democratic justice system, the presumption is innocent until proven guilty, and to be proven guilty, the case must be presented in a way that eliminates reasonable doubt. In an arbitration system, it doesn't work like that. An arbitration system is based upon balance of probabilities. There's no prosecutor and no defendant. You have two people or two parties presenting their case to an arbitrator. The arbitrator has to make his or her decision based upon balance of probabilities. And the arbitrator has to have the authority to have final and binding say on the issue at hand, or the arbitration system won't work anymore. The reason why presumption of innocence doesn't come into this is it's not really about justice. An arbitrator is there to settle a conflict between two parties. There's no abstract concept of justice involved. The arbitrator has been chosen by two parties who are often totally hostile to each other. And so the arbitrator must, in as much as it's possible, satisfy both sides, or at least get a reputation for impartiality. And impartiality and justice are not the same thing, at least in terms of their ultimate goal. I say that the present justice system is not impartial in that it wants to err on the side of caution. It wants to make sure that some abstract concept of justice is served by the courts, the judges, the juries, that sort of thing. Whereas an arbitrator is only interested in resolving a conflict. The arbitrator is only interested also in maintaining the reputation of being someone who is capable of giving a balanced award in an arbitration, not so much a fair or a just one. Because if you end up constantly erring on the side of one particular point of view, or erring on the side of caution on towards one particular point of view, suddenly you're out of work because nobody wants to hire you because you're not really impartial. You have some abstract ideas as to what justice is, that sort of thing. And in this case, arbitration becomes a commodity. And my experience with arbitration, I'm kind of cynical about the whole thing. I suppose in the same way as most people are cynical about the courts and the prisons and the cops, in that it eventually becomes a case, in my opinion, of it being a crapshoot, really. When you go into an arbitration, regardless of how much evidence is presented, how much it resembles a court case, ultimately the arbitrator has to sort of, at least in terms of his or her reputation as an arbitrator, as a person with a commodity, i.e. arbitration to sell in the marketplace, has to show that their judgments are ultimately even unpredictable. It's not a case of sticking to one abstract idea, one abstract concept of justice. It's balance of probabilities. The arbitrator has the authority to make up his or her mind as to what actually happened without any presumption of innocence or guilt, and make an award that both sides have to stick to. Now, that's very hard to do in practice, and the best way to maintain a reputation as an arbitrator is to make very erratic, I shouldn't say erratic judgments, but unpredictable judgments that tend to be sort of all over the place in terms of their emphasis. That way, no one can accuse you of preordained bias. So that's the problem that I have with private or arbitrary justice, in that if I am brought before an arbitrator for murder or for some other act of violence or aggression or an overt crime, as we would call it, against someone else, where in a crime there is a victim and there is a perp, it's not looked at that way by an arbitrator. An arbitrator goes by balance of probabilities. In other words, the plaintiff has to prove to the arbitrator, A, that a crime even took place in the first place, and B, that the other person in this arbitration case is the person who's guilty of it, and C, has to do so in front of an arbitrator that is acceptable to the person who is accused of this crime. The possibilities for abuse and error are enormous. Again, I'm not making a case for our present justice system, but it's the best that we've got, and it's thousands of years old, and it continues to reform itself. I don't think any organ of our society, or our state, if you want to call it, comes under closer scrutiny than the judiciary. There's TV shows about it, there's reality TV about it, there's everything you can imagine putting the justice system under a microscope. So it does have the capacity to reform itself and correct its own abuses, and it has done so. That's why I don't think that arbitration is the way to go, and in fact, I would say, as I always say, the cure would be worse than the cold, in my opinion. Thank you.